Welcome and thank you for joining part one of Seyfarth's webinar series from our 2024 Cal-Peculiarities publication on PAGA Pecularities. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. We've recently introduced a streamlined process for accessing and submitting CLE forms. Towards the end of the presentation, you will notice a QR code on the left-hand side of a slide and all the necessary information on the right. Simply scan the QR code with your smartphone and it will direct you to a digital attendance verification form. Once you've completed the form, you can submit it electronically. This saves time and ensures accurate processing of your CLE credits. Copies of the webinar recording and presentation materials, along with CLE form, will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Laura Hain to get us started.
Thank you, Brenda. Hello, everyone. Welcome to part one of our three-part webinar series, kicking off the launch of Seyfarth's 2024 Cal-Pecs publications. We are very excited today to kick off this series. Again, it is a three-part series, and this is part one of the series. We are going to be talking about one of the hot points here in California, which is PAGA. Next slide, please. Okay, so here's the agenda. We only have 30 minutes to discuss today's topics, and while we could probably go into PAGA and all the intricacies of California law for hours, today we're going to focus on three primary topics or three primary points. The first thing we're going to dive into are just the new developments and recent reform to PAGA. That is probably why most of you are here, because that just took place in June of this year, signed into law. We'll talk about it a little bit later, July of this year. So we will go into that and really the things you need to know with regard to the reform. The next point we're going to transition to is talk about employer action and really what employers can or maybe should be doing as a result of the reform to PAGA. And we refer to kind of the new PAGA or the reform to PAGA as new PAGA. So if we use those terms, that's what we're referring to. And then finally, we're going to wrap it up by highlighting case law under the old PAGA statute, how it's being amended, and how we kind of see that play out recently. Next slide, please. All right, so my name is Laura Hain. I am a senior associate here at Seyfarth. We also are very lucky to have Philip Ebsworth here. He is a partner in our class action department. Philip is a resource for all things PAGA and class, so we're very lucky to have him here today. So thank you. And next slide, please. Okay, new PAGA and reform. So things you need to know. Next slide, we're going to jump right in. And let's start off just with a little bit of background on the PAGA reform. So on June 21st, 2024, which was about 2 months ago, or a little shy of 2 months ago, Assembly Bill 228 and Senate Bill 92 were introduced to the floor, proposing significant reform to PAGA. Now, the proposed reforms have been heavily negotiated between both labor groups and business groups, so this was kind of a big deal. I think Governor Newsom said this has been decades in the making when he was signing this into law. So as many of us know, PAGA cases in California have been on a very steady increase. In 2022, there was a slight decrease of notices that went out. I believe the number was 5,817, but then came 2023, and of course we saw a resurgence in PAGA notices, rounding out the year with 7,909. So in this year, we're continuing on the upward swing. So the PAGA bill, after it was introduced to the floor, Governor Newsom signed it into law on January 1st, 2024. Again, the reform portion of it. While the reform is really in the infancy stages, one of the first questions that we get is, well, does this new reform to PAGA apply to my ongoing litigation from earlier this year or from 2023? Generally, the answer is no. The law sets forth that the new provision will apply to PAGA claims where the PAGA letter was submitted on or after June 19th, 2024. So again, generally speaking, these new PAGA reforms will apply to cases we see coming in now. So PAGA letters were sent in maybe in June, and we're going to slowly see those become lawsuits once the period has passed. All right, next slide, and I'll go ahead and pass it on to Philip.
Yeah, thank you, Laura. So, as Laura said, we're about 2 months out from when the reform happened, and so we're going to start seeing in the next couple of weeks the vast majority of this first wave of lawsuits that are brought under new PAGA being served, being filed, and so it's kind of timely that we're going to talk about this and talk about what are kind of these major changes and what's different now than it was, just a matter of months ago. So, I mean, the biggest thing that the biggest change and biggest change to the employer's benefit is that really the scope of PAGA actions are going to be significantly reduced. So under old PAGA, one of the things that made PAGA so difficult for employers is that a PAGA plaintiff need only prove a single labor code violation. So maybe like one day they didn't get a full 10-minute rest period. Maybe they had all they needed at a deposition, for example, was to testify that a supervisor spoke to them and asked them about a work-related thing for one rest period. And that unlocked the doors for them and their attorneys to essentially conduct a wholesale audit of an employer's wage and hour practices. And so that led it to be a very difficult and often unwieldy process for employers to defend these cases because new theories could pop up at almost any time with the lax, kind of very lenient standards that plaintiffs had to meet both on pleading and on this broad, expanded standing. The reform really brings us back to a traditional concept of standing. So now for a PAGA plaintiff to pursue a PAGA claim, they can only pursue those claims on behalf of the employee population if they personally had experienced those claims. So gone are the days where you have a plaintiff who has maybe one labor code violation in their entire employment, representing an entire class of tons of different claims which they'd never even got close to experiencing themselves. We're back to this kind of more traditional concept, which is what we deal with in class actions, both in California and across the country. And that's really going to play a big part in how not only employers defend these claims, but also the kind of exposure that employers are looking to as well, in addition to the new penalties that we'll talk about in a moment. The second thing that's important to note about the change in standing for these new PAGA actions is that the new statute confirms that the plaintiff must have experienced their labor code violations within a year within the 1 year statute of limitations. So that would be a year and 65 days typically from when the PAGA action is filed. Now that puts to bed some arguments that plaintiffs' bar had been arguing over the last few years, following a Court of Appeal decision that had come out, which had somewhat insinuated or maybe just poorly worded their opinion and had been used to argue that there was no statute of limitations at all for a PAGA claim, that a plaintiff who experienced a labor code violation decades ago could still bring a PAGA claim many, many years later. The reformed PAGA puts that argument to bed and makes very clear that the plaintiff must have experienced their labor code violations within a year or within the 1 year statute of limitations. Now, the other big development with our reformed PAGA that you might have seen a lot of people talking about is the codification of this concept that PAGA claims have to be manageable. Now, that's been a battleground for the plaintiffs' bar and employers over the last couple of years. resulting in a recent Supreme Court decision, which kind of split the baby somewhat, but ultimately was a good decision for employers. And the new PAGA really codifies that decision, the Estrada decision. And in that the statute now says that a court may, quote, limit the evidence to be presented at trial or otherwise limit the scope of any claim to ensure that the PAGA claim can be effectively tried. So again, this is a big win where the plaintiffs bar, since Estrada had come out, had been arguing that, you know, it means that claims don't have to be manageable because it doesn't, employers can't move to dismiss the claims on manageability grounds. However, the statute has codified essentially what the Estrada decision says, in that that would limit the evidence to be presented. And so that is still a very effective tool, a very good win for employers, in that plaintiffs cannot pursue a PAGA claim that's totally unmanageable and unwieldy. It still needs to have a plan to be able to try these at trial. So that combined with this reduced scope of standing, we envision really limiting the scope of PAGA claims moving forward under this reformed PAGA. And if we turn to the next slide, the other big thing that we see, the big news, the big headline that the employer groups and business groups were excited about in this reform PAGA is the substantial changes that have been made to the penalty structure. So previously, PAGA was kind of this headline thing that you'd see as an example across the country of the cost of doing business in California, with these crazy high penalties, these very high verdicts coming out, you know, in the hundreds of millions of dollars for very technical and really, you know, violations that weren't causing any harm to employees. So a huge amount of work went in the negotiations into this reform about how the penalties under PAGA can be adjusted so that they are more fair and equitable. And obviously everybody can have an opinion as to whether it reached that goal, but there's certainly been drastic improvements for employers in these changes to the penalty structure. So as you can see on the slide, we've highlighted kind of 9 of the key changes that we see in that changes to the penalty structure. The first one being this tiered cap on what can be on penalties. So the first one being a 15% cap on penalties for employers who have, quote, taken all reasonable steps to be in compliance with the labor code. Now, the statute does provide some examples of what that might look like, including periodic payroll audits, disseminating lawful written policies, training supervisors on, you know, wage and hour compliance, and those kind of things. So the first step, I think, and we'll talk about this later, is that, look, there's a way for employers to proactively be reducing any potential PAGA exposure out there. And obviously a 15% cap, an 85% reduction on what penalties would have been available under old PAGA is a really, you know, it's a big reduction. So that's something that Laura will talk about shortly, about how employers can be proactively reducing any possible exposure under PAGA. Now, the second tier of penalties under this new PAGA structure is a 30% cap on penalties. So still a huge reduction on what would be available under the prior system. And this is for employers who take, again, all reasonable steps, but the timing is slightly different. And this is for taking reasonable steps after you receive a PAGA notice. So PAGA notice comes in the door and it makes certain allegations. If an employer can show that they've taken all reasonable steps to, you know, investigate those allegations and correct them, that would be something that would entitle the employer to this 30% cap on the penalties. Now, this question of whether you've taken all reasonable steps or not to satisfy this 15 or 30% cap, there's no real explanation as to what there's no hard line, we should say, as to what satisfies that standard. And so that's likely going to be something that is debated both in court and in mediations of PAGA claims. And we'll see that as well. Laura will talk in a little bit about the new cure provisions. In all of these scenarios, that's going to be a hot topic of debate, likely for plaintiffs and their attorneys, who are going to try and always get into the higher tier of penalties. But nevertheless, there are a host of things that employers can and hopefully should have already been doing, just as good practice, but definitely now as something to point to show how the benefit of some of these practices, including audits and trainings on wage and hour compliance, and it can have a real kind of impact on the kind of exposure that a business is exposed to under PAGA. Other improvements or changes to the penalty structure, we see a cap on penalties for wage statement violations that don't actually cause an injury. So previously we've seen, frankly, some of the largest PAGA settlements or verdicts have come out on kind of innocuous wage statement violations. So whether it be not correctly naming, having the full employer's name on the wage statement, or missing off kind of some small but ultimately crucial information on a wage statement, would result in verdicts of tens or hundreds of millions. The reformed PAGA really puts a limit on those kind of claims, and that will really, for those of you who reside out here in California as well, you might have seen a bunch of ads and commercials on TV and social media about how these kind of technical wage statement violations were very much kind of the face of the ballot measure that was on for this November to repeal PAGA. This is very much kind of the headline of how crazy PAGA is. And so this reform was to limit those kind of the penalties that are available for those kind of violations. And so now, if a wage statement violation does not actually cause any harm in the same way that a plaintiff would have to prove for a pure Labor Code 226 claim for wage statements, then the penalty is capped at $25. So that's a 75% reduction from what would have been available to the typical $100 penalty. And additionally, the bill confirmed that the wage statement penalties are only available for actual wage statement violations. They can't be derivative penalties. So if there was a underpayment for overtime or for off-the-clock work, that doesn't entitle plaintiffs to get a second PAGA penalty for an inaccurate wage statement as well. And that's applicable. That concept of no derivative penalties is also applicable to things such as waiting time penalties as well. Again, the statute is very clear that PAGA penalties under this new reform PAGA are only going to be applicable to actual true violations and not for the derivative violations that we often have seen in the years past, and the violations we still see in class actions, where maybe there's a very small underpayment in, let's say, a miscalculation of the regular rate of pay. But the penalties that rack up on that for waiting time penalties and wage statement penalties and PAGA penalties is what caused those errors to possibly be very costly. Reform PAGA gets rid of the derivative penalties in the PAGA context. So again, those small errors will not now cause compounding derivative penalties, making the potential exposures so much more greater than the actual harm to employees. Reform PAGA also has codified other good aspects that the employers have argued for and obtained from the courts in the last couple of decades. So the court's discretion to reduce penalties is again codified. That had long been kind of the accepted standard in PAGA, but the court's discretion now to adjust penalties based on the circumstances of the case has been codified in this new PAGA. So in addition to these caps that we've seen, and no derivative penalties, even with these reduced penalties that are available, the court still has the discretion to reduce that even further if there are good arguments to be shown why, even with these reduced amounts, that it would be unjust, arbitrary, oppressive to award that amount to the plaintiffs. Other good news for employers in the change to the penalty caps, the penalty structure, is that those employers who were operating on a weekly pay cycle are getting some relief. So previously, employers who were paying their employees on a weekly pay cycle, typically to, for the benefit of the employees, to increase, how often they're getting paid, they would get, doubly exposed in PAGA, because PAGA is measured purely on a pay period basis. So when you're paying employees twice as often as the majority of employers in the state, then the amount of penalties that you were exposed to under PAGA was doubled as well. The legislature and the business and labor groups who negotiated this reform have recognized the unjust application of that to those employers. So they've gotten some relief in this reform as well. And so any penalties that they're assessed are halved to kind of put them on the same playing field in terms of potential exposure as those employers who are paying employees on a bi-weekly basis. And last but not least, the biggest change, the headline change that labor groups were proud to trumpet with this new deal, is that the amount of money that the employees themselves are receiving under this new PAGA has increased. So famously, they receive 25% of any PAGA award or settlement, and the rest went to the state. That has been bumped up to 35%, and so there has been an increase in what is being paid to the employees under PAGA compared to what we had previously. If you turn to the next slide, I think I'm going to hand back to Laura to talk about, in this new age of PAGA that we're under, what employers can be doing to proactively reduce their exposure with these new penalty caps.
Thank you, Philip. Next slide, please. All right, so one of the things that Philip kept bringing up was, the cure provision as part of this, the new reform. And employers, we get questions, they're wondering what, if anything, can they do to benefit under these new cure provisions? So I want to talk about just kind of what the cure provisions are. What it does is it encourages compliance with labor, wage and hour laws by capping or even eliminating PAGA penalties on employers who quickly take steps to fix the policies or practices and then make the workers whole after they receive a PAGA notice. Now, it can be done before receiving a PAGA notice, which is what we would recommend, and we'll talk about audits and things employers can do to try and eliminate risk there. But the codification of it has timing provisions on if you receive a PAGA notice, you'll have a time period to cure. Now, to lawfully cure the wage and hour violation that's being alleged in the notice, let's say it's a wage statement or failed to provide meal and rest breaks, what the employer has to do to cure to legally cure is to cure the underlying conduct. So cure the alleged violation. And then they also have to make the employee whole. Now, the violations that employers can cure have been expanded by this PAGA reform. Before, that was very limited, but now it includes failure to provide meal and rest breaks, minimum wage violations, overtime violations, expense reimbursement, wage statement violations. So it is very much expanded, and employers now have an opportunity to say, hey, I've got this PAGA notice. Many times as we know, there are a gazillion allegations that are alleged, but sometimes they're a little bit more narrow. But employers can receive these and say, okay, what can I do to cure? Is this something that I'm allowed to cure to try and avoid these insane PAGA penalties, which Philip discussed are now capped, but still have a big impact on employers. So pursuant to the law, to make an employee whole, that's kind of where we get a little bit gray, a little bit tricky here. We're going to have to kind of see how this plays out because it is new. There are 4 key components here that have been laid out. So I'm going to go through all 4. To make an employee whole, you have to pay the employee in full the amount sufficient to recover any unpaid wages due for the prior 3 years. So that is step one of making the employee whole in order to cure under these cure provisions. The second part of it is you have to pay 7% interest on it. The third part is you have to pay liquidated damages as required by statute. So some statutes have that liquidated damages provision. And then the fourth part, which is really where we get a little bit gray or a little off here, is you have to pay, the employer will have to pay reasonable lodestar attorney's fees. Generally, these will be determined by the LWDA or a court if the attorneys are involved. But that is what is set forth on how to make the employee whole with the statute. So, you know, while we don't know exactly how this is going to play out in practice and whether or not, you know, attorneys are going to be, plaintiffs' attorneys are going to be reasonable in, you know, saying what their attorney's fees are going to be and if they can be paid, or let's say you get a notice and it's very limited. It says, oh, there is this one issue with off the clock time work and they are clocking in, you know, to record their time before they get on premise, and you can easily fix that, or something small that you can easily fix. This may be a way to easily cure, you know, and avoid litigation in full and PAGA penalties. I want to then, you know, kind of transition into the third point here, which is an additional remedies for, so there's remedies for big employers, which are defined as over 100 employees, and smaller employers, which are defined as less than 100 employees. So employers with less than 100 employees have additional options. Beginning in October 2024, small employers, again, less than 100 employees, can submit a cure proposal within 33 days of receiving the LWDA PAGA notice and request a conference with the LWDA to determine if their cure remedies are appropriate. So that is a pretty, I mean, we don't know. It could be a very, very useful tool for small employers to use to try and mitigate these claims or avoid litigation altogether. Large employers, so ones that are more than 100 employees, may file. So what they can do is they can file a request with the court for an early evaluation conference and request a stay of the court proceedings. There is no definition. This is where, again, it gets a little, this is all new. So we're going to have maybe a little bit of ambiguity here, but there's no definition of early evaluation conference. It's not defined by the statute. So what we anticipate is that different jurisdictions are going to employ this maybe different ways. They're going to maybe have panels. They're going to have people, you know, informally agree. But the point here is that large employers, when they receive PAGA notices and then a claim, they can immediately request that early evaluation conference and stay the case while they have that. There is another thing too that is brought up with these cure provisions. If the PAGA notice is wage statement specific, so if it's like, hey, you have the only issue we have with you, company, is that you didn't include a period and an ink on your wage statement, or something, you know, very, very specific to wage statement violations. There is a separate cure provision. So beginning in October, you're going to want to start, you know, looking at this now, but beginning in October, if the only allegation is that it's wage statement violations, the employers have different ways to cure, which includes making the change on the wage statement to make sure it's compliant, and then providing written notice via certified mail to the plaintiffs and to the LWDA. So, you know, like Philip was saying earlier, a lot of this was brought on by some of these, you know, class action attorneys who are saying, hey, wage statements, you know, here we can get lots of money from this. The statute addressed this pretty specifically. I see we're running really short on time, so I am going to go ahead and go to the next slide and pass it on to Philip, and I think he's going to talk about old PAGA and some updates we want to get through really quick.
Yes, thank you, Laura. So in a minute or less, I'm going to really touch on some of the developments that we've had in the last year under the old PAGA, which is, you know, still the vast majority of PAGA cases that are currently in litigation are going to be under the old scheme. And so as the law continues to change, as it always has done over the last 25 years in PAGA, pretty quickly, we need to stay on top of these developments. So of course, the biggest thing that's been happening in PAGA in the last year is, the arbitration of individual PAGA claims. And so we've seen obviously a severe increase in challenges to arbitration agreements by the plaintiffs bar, and that's going to continue to be a trend. And so the takeaway there is to be having a look at your arbitration agreements that are in place, whether there's any changes that need to be made that would provide the extra security that you're looking for in terms of the arbitrability of PAGA claims. And then more recently, we've had a host of decisions really affecting about how PAGA settlements, the kind of finality that employers can get in PAGA settlements. Most recently, the Turrieta decision came out, I think last week or maybe 2 weeks ago, which held that non-parties to a PAGA case, so typically other plaintiffs pursuing overlapping PAGA claims, do not have standing to intervene or object or in other ways kind of interfere with attempts to get PAGA settlements approved. And we've also seen kind of a bigger crackdown, I would say, on courts making sure that any PAGA settlements that are being approved, that the employees, the employee plaintiffs have the authority from the LWDA to actually settle those claims out on behalf of the aggrieved employee population. And so that has a double-edged sword in terms of, it's great that an LWDA notice, plaintiffs are limited to what's in that notice, but it also means after the fact, if you're trying to get a settlement that goes beyond that, we need to be working with the LWDA or plaintiff's attorneys to make sure that any kind of whatever's being included in the release was also included in that PAGA notice. We had hoped to have a time to answer some of your questions today. Unfortunately, we've run out of it. Anything that you've put into our Q&A box, we will respond to. We'll get your email, we'll get your question, and in the coming days we can get you your responses. We're sorry that we haven't had time to get to those today, but with PAGA reform happening just 6 weeks ago, we knew it was going to be a jam-packed webinar today. Up on the screen, you'll see the QR code. You can scan that to get to our new CLE process. We'll leave that up on the screen for as long as you need it to get your CLE credit for those of you who are looking to get that. Thank you so much for attending. We really appreciate you joining us today to talk about PAGA. And like I said, for those of you who have reached out with questions, we'll be in touch in the coming days with some answers. So thank you so much. We'll see you next time.